Good afternoon, good evening. Actually, I should say good evening. Welcome to Koźmiński University. I'm professor of finance at Koźmiński University, so I'm going to talk a little bit more from the economic point of view, but nevertheless, we have great presenters who are lawyers, and they're going to talk about the international investment from a legal point of view. So I was asked to make an introductory speech, and my speech actually will be about some advantages and some evidence, research evidence, which shows why actually the countries should support foreign direct investment, international investment, and how they can do this. And actually, let me first define what do we mean by foreign direct investment or international investment when we talk about them. So, well, actually, this is the investment is made by a company or individual investor from one country to another. And they are very important. They really play a very important role, both to beneficiary countries as well as to the providers of capital. The key principles behind existence of direct investment are based on assumptions which basically are derived from macroeconomic point of view, which basically shows that the investment, that international investment, allow to optimize the costs of the costs, which result, of course, from the competitive advantage. The analysis, the academic analysis, show that countries can benefit a lot attracting foreign direct investment. They promote the competition in a country, they bring the capital to the country, they bring the technology to the country, and they also, the recipients of foreign direct investment often gain employee trainings, and of course they contribute to the human capital development in a host country. At the same time, of course, I should mention that the companies which invest in host countries, they contribute to the tax revenues in a host country. We have also some academic evidence which find a huge correlation between a capital inflow coming, of course, from direct investment and domestic investment. This is very interesting. And this analysis shows that foreign direct investment brings almost 1-for-1 increase in domestic investment. With almost non-discrepancies in the host countries, and the research was done in a very wide sample covering 58 countries, including 18 developing countries. Moreover, the researchers also discovered that there is an economic link, significant statistical link between the foreign direct investment and economic growth in a host country. What do the countries have to do in order to attract foreign direct investment? Well, of course, there is a lot of literature on this, and there is, of course, the debate how the countries should reform the systems in order to attract foreign direct investment. And of course, there are a lot of them, but let me mention those which are very often mentioned in the literature. So this incentive programs can be divided into the fiscal and financial incentives. And they can include as following. These are the tax concessions in the form of reduced corporate tax rate. This might be tax holidays. This might be accelerated depreciation allowances on capital taxes. This might be exemption from import duties and duty drawbacks on exports. This might be the direct contributions coming from the governments as grants, loans, loan guarantees, preferential interest, or public venture capital. There are a lot of examples of companies which use such incentives. The example of such deal which was lately widely covered in the media is Apple deal with Irish government, where the regulatory corporate tax rate in Ireland is 12.5%, and Apple is charged with only 0.005% of tax. Another example is BMW factory in the United States, when a company received a sum of $130 million in incentives, and this resulted in 2.2 billion investment, supported by creation of 5,000 new jobs in a country, in a district. Poland. Let me say some word about Poland, since we are in Poland. What about Poland, and how, where is Poland located on this map of international investment? And in fact, I have to say that we are quite successful in attracting direct investment, international investment into Poland. And the stable economy in the recent years, low interest rates, which are set to rise not sooner than in the first half of 2019, great economic outlook for the next years, and competitive job market are the main factors, the key factors which support the investment from abroad. That is why Poland has attracted a total sum of $30 billion in terms of the investment, and we are located on a second place in terms of the volume in the European Union. The total investment number was 335 in Poland, and this has translated into the potential of 86,000 of new jobs. According to Polish Investment and Trade Agency, the majority of the projects attracted by Poland are the large investment creating at least 100 jobs. And in terms of the sectors, the most of them are in construction, 95 projects, IT, the automotive industry and transportation. Of course, we have also some drawbacks of these incentive programs, and we have to mention that domestic organizations often perceive preferential treatment in form of incentives as unfair. European Union took a strong stance on mentioned Apple case and has taken the legal actions to force Apple to settle its obligations to the level of Irish corporate tax, explaining that the degree of tax incentives from which Apple has benefited was unfair and resulted in unfair competition. The same position has taken the European Union in terms of the incentives, saying that such incentives which the countries give for foreign companies are unfair and should be eliminated from the European Union. We have, I guess, I have mentioned very broadly about the foreign direct investment advantages and disadvantages, but I guess our speakers, and let me introduce our speakers for today panel, gonna a little bit deepen some of the aspects I have mentioned in my introductory speech. Let me first introduce Dan Coker from the UK, and then I think you're gonna talk about the English law, right? Yes. So, as the name suggests, we have Rafał Kluziak, right? The presenter of the Polish law. We have the Matthias Schauffacher. Yes, so the representative of Swiss law. And we have still one presenter missing, Singh, I guess this is a correct pronunciation, and Singh gonna talk about the Indian law. Since I represent the finance department and I spent 7 years in Germany, so I would like to have, I don't like mess, so I would like to have a nice order. So let me first say the rules for our panel. The rules are following: that we have a speech presented by presenter, and at the end of the session we have some time for questions. Dan, the floor is yours.
Okay, thank you very much for the introduction, and thank you especially to ELSA for the invitation. As a student at my university in the UK almost 25 years ago, I took part in an ELSA moot and very much enjoyed it, and never expected that I would have the privilege almost 25 years later of coming back to another ELSA event. So I hope that it will be a great event, as I'm sure it will. English law, let's see if we've got some slides here. Yeah, that's the one. Okay, great. Thank you very much for the help there. It's always the case that lawyers are completely incapable of operating technology. So now we have some slides which will be quite important for this presentation. What I'd like to talk about today is not just investments in England, because that would be a relatively narrow subject. One of the most significant parts of the UK economy is the services industry in the City of London, which includes the legal profession, insurance, and wider financial services. The significance of the legal profession in the UK is that English law is so frequently chosen as the governing law for financial transactions and investments around the world. And that's why I'd like to broaden the scope slightly in the context of English law investments. And when I'm talking about English law here, I could equally be talking about the laws of many other common law jurisdictions, because they are all very similar. The legal systems of the world, if you're into taxonomy, dividing things into categories, could be more or less divided into 8 legal systems. UK-based common law, US-based common law, the Roman Germanic systems, the Napoleonic systems, mixed civil and common law jurisdictions, such as Scotland, for example, the Islamic jurisdictions, some new jurisdictions, and some unallocated jurisdictions like North Korea. We don't know much about the legal system of North Korea. Many of us are not keen to find out. How does that look on the map? So if you imagine those colors, and we're going to be focusing especially on the blue-colored jurisdictions here, which are the common law jurisdictions. When it comes to financial law, one of my colleagues in our firm, Philip Wood, came up with a rather straightforward 5-point test for assessing which legal systems are most friendly towards debt and therefore most likely to be selected by lenders and investors as the governing law for carrying out financial transactions. And he illustrated this in diagrammatic form. So if we oversimplify the legal jurisdictions of the world into 3 and look at the jurisdictions that use the Napoleonic Code or some derivative of that, and then the Roman Germanic jurisdictions, and then the common law jurisdictions. And the 5-point test is based on set-off, the possibility of setting off debts on an insolvency, the ability to transfer debts without notice on insolvency, the availability of security, and whether that is protected on insolvency, and the availability of the trust. The trust is a concept which involves a split between legal and beneficial ownership. The trust was devised during the Crusades in the UK, when Crusaders went off on their missions, and they were going to be gone for quite a number of years. They needed someone to look after their property while they were away, to hold the legal title to the property, so that they could sign any documents and protect it from other people getting onto the property. But they needed some beneficial ownership, so that when they came back, they were going to have the right to use the property. And that grew up into the trust, the split between legal title, the formal aspects of property, and beneficial title, which is the right to use and get the profits from the property, which is extremely useful when it comes to financial transactions, especially when you are creating security. This could be the subject of another lecture, which I'm not going to cover now, but I just mentioned the trust for a moment. And then the question of asset tracing upon an insolvency. Is it possible to trace through several holders of assets despite insolvency to get back assets which properly belong to you? So the Napoleonic jurisdictions are very debtor-friendly on all of these tests. The common law jurisdictions are more creditor-friendly, pro-bank, pro-lender, and the Roman Germanic jurisdictions are somewhere in the middle. So how does that look in relation to security interests? For example, look at the coloring of the map. The dark blue color are the jurisdictions which favor security. The green jurisdictions also favor security, favor the lenders. And if you compare that map to my next map, which is the members of the International Cricket Council, you will see that there are some similarities. And lawyers do refer to cricket-playing jurisdictions. A cricket-playing jurisdiction is generally one which is pro-lender and common law. I think students of history could probably work out that there is some sort of link in that the British colonists, of whom we are not proud, when going around the world, took the concept of English law, common law security interests, and cricket to all of these jurisdictions, and these jurisdictions have perhaps kept some of the better aspects of colonization, which is arguably a good legal system and cricket, and I hope got rid of the worst elements of colonization. And similarly, if you look at the trust, the dark blue color shows that the trust is widely recognized, and it's a very similar pattern. So let's look at the insolvency policies in pro-creditor jurisdictions against Chapter 11 jurisdictions, Chapter 11 being the name for the US insolvency process, which despite the US scoring quite well on other pro-creditor measures, is somewhat more pro-debtor when it comes to insolvency. And again, we look at the availability of set-off, universal security interests, and preferential creditors. There will be a short list of preferential creditors in a pro-creditor jurisdiction. Preferential creditors will be, for example, when a company becomes insolvent, who is going to get paid first? Often it will be the employees who will get their wages first before the banks and other arguably more greedy creditors get paid. That may seem perfectly fair. And then you come on to the question of the taxman. Whereabouts does the taxman come in the order? Is the taxman some beneficent custodian of state interests, so he should get paid early? Or should the taxman be paid pro rata with all of the unsecured creditors? That is a debate for every jurisdiction to have, and it's the sort of factor that might influence people when investing or especially lending into jurisdictions. In the pro-debtor jurisdictions, there will be a stay on enforcement of security, which means that the people who hold security, such as a mortgage or a pledge or a charge over the assets, will not be able to enforce during the insolvency process. And there will be a stay on counterparties' rights to terminate certain contracts. There might be judicial reorganizations, and the debtor might remain in possession of its assets. So this is all pro-debtor, and as a matter of policy, you might say that a pro-debtor jurisdiction is right because it promotes the survival of the business rather than the failure of the business, and arguably the ongoing survival of the business is better for the economy as a whole than arguably greedy creditors taking their pickings and the business failing. When you look at that in the context of global bankruptcy law, which are the pro-creditor jurisdictions? Again, if you look at the blue on the map, those are the most pro-creditor jurisdictions which we see there, and the green jurisdictions are the more pro-debtor jurisdictions. So again, factors which might influence investment advice. What else might you think about when it comes to deciding where to make an investment? One issue is perhaps corruption, and how corrupt or clean is the jurisdiction. And here I've put up the top 20 jurisdictions in terms of the least corrupt jurisdictions according to a survey compiled by Transparency International. And since I'm meant to be talking about English law and the United Kingdom here, I thought I would put this up so that you can make your own judgment about how well the United Kingdom does in this table. So it comes equal 10th. Denmark or New Zealand is clearly the place to go according to this survey for the lowest level of corruption. And I've not put the most allegedly corrupt countries up here, but if you go to the website of Transparency International, you can study the whole list at leisure. Okay, other reasons for the popularity of English law. One must be the ease of doing business in the English language. There are some other languages which are very, very popular. For example, French is arguably the language of ballet, but when it comes to business, English is a widely adopted currency. And I've put up here a quote from arguably the most famous English judge of recent times, Lord Denning. The case is not remotely relevant to business, but if you read at your leisure when you download the slides from the website, this print, which is probably very tiny on this screen, you will see the simplicity of the English language which this judge uses. This judge started out life as a mathematician. I always say that English lawyers are the least qualified lawyers in the world because you can become an English lawyer without studying law at university, and then do a 1-year conversion to law. So as English lawyers, we don't really go in for academic study as a profession very much, and therefore often come up with some very pragmatic outcomes. So Lord Denning started out as a mathematician and then became the most influential judge in the land. As a mathematician, he didn't bother too much about legal principles and did what he thought was right, and came up with some logical justification, adapting the law to whatever he thought was right. But the reason I put him up here is for the simplicity of the language that he uses. Very short sentences, and if you can emulate that language in drafting, you will make life very easy for your readers. The next reason for the choice of English law is that it is generally pro-business. The courts understand that business needs to be done and therefore make it attractive as a governing law for investments. Many English law cases are shipping cases, such as this one. This was the name of a ship, the Moorcock. I'm not going to go into the case in detail, but I will just highlight this quote in the middle of the next slide, which sums up the attitude of the English courts, that in business transactions, the law desires to give effect to the business efficacy of the transaction. So it's not looking at the black and white words on the page. It's not taking a literal approach. It's about business efficacy. And that's what English law is very keen to encourage. To give an example for another case, again to study at your leisure, this was the Investors' Compensation Scheme case, a speech by Lord Hoffman in the days when it was still the House of Lords. He was a South African judge in the House of Lords in the UK, and he came up with a 5-point test for interpretation of contracts where there is some form of ambiguity. And I won't take you through each of the 5 points, but if we look at the 5th point, again at the center of the slide, putting aside semantic and syntactical analysis of words in a commercial contract, but looking at business common sense. So those are the reasons why English law, in my perhaps biased view, are a very good choice for international investments. Happy to take any questions. Yes. Yes, I can hear you, yeah.
Thanks. Well, as far as I know, in some jurisdictions, you were talking about the pro-creditor jurisdictions when it comes to insolvency and pro-adapter jurisdictions.
Yes.
So as far as I know, in some jurisdictions, there is no prohibition for doing this oh my gosh, I'm sorry, it's just I'm nervous a little bit. So in some jurisdictions there is a possibility to hold the procedure in arbitration instead of like state court. So do you think that these jurisdictions, they are better for creditor or debtor in this situation? And if yes, if they are better, then is it better to come to such approach? And
right. Very good question. And this is a topic that I particularly like, about the merits of choosing the courts versus arbitration. So the question is, when it comes to enforcing security interests and so on, should you look for a jurisdiction which is recognizes arbitration, or do you need to rely on the local courts? Excuse me. And my answer is that if you have got a jurisdiction which has good, reliable local courts with a fast process, that is the best choice when it comes to the enforcement of security. However, there are many jurisdictions where the courts are not reliable. You get judges which know nothing about business, and you will get slow litigation processes. So you might not want to choose the courts in those cases. You might therefore choose arbitration. What are the advantages of arbitration? You can choose the seat or the legal place, which governs the regulatory procedure of the arbitration. You can choose the physical place of the procedure. You can choose the rules of the arbitration, be it UNCITRAL or ICC or London Court of International Arbitration. That there is arbitration in most countries. Here in Warsaw, there is a set of arbitral rules. Arbitration can be chosen to be confidential. You can choose the arbitrators, so you will have arbitrators who know something about the subject matter of the dispute. And the great thing about arbitration is that when it comes to reciprocal enforcement of awards, there are many more options than there are with reciprocal recognition of judgments. So many countries are parties to the New York Convention on the enforcement of arbitral awards. Then there are countries which recognize one another's court judgments. So on that basis, you might decide that arbitration is the way forward. Once you've got your arbitral award, clearly you have got to enforce it in the jurisdiction where the assets are located against which you are enforcing. So you might need to think about how that country has implemented the New York Convention, whether it is going to raise any public policy grounds for refusing to recognize an arbitral award.
Thank you so much. And just a little remark, I'm just wondering, I'm sorry for taking your time. It's just, what about then of cancellation of arbitral decisions? Because I know that there is such a trend, let's say, that the recent years, some arbitral decisions that were made under the ICSID, they were cancelled on the grounds of the Article 51, as far as I know. So it's kind of like, it's against of the principle of the, how to say, the end.
So cancellation of arbitral awards in which country?
It's international. Like, I don't know, I mean, that was a case, but I don't actually, unfortunately, remember the names of the cases. But that was under the ICSID. And for example, there was a case between Germany and some country in Africa, but I don't remember the name. So they were cancelled just because some procedural rules were breached. And that is why it's kind of an appeal, you know, the second procedure that is held under the arbitration in that case. So, and we were taught that there is no appeal when the arbitration was held and everything like that. So.
Yes, it's fair to say that in most jurisdictions, the scope for appealing an arbitral award are extremely limited. And that is clearly a risk with arbitration, especially if it's some issue of fact or law. The possibilities of appealing an arbitral award are extremely remote.
Thank you.
Okay, thank you very much.
Thank you for the question. I'm sure that many of you have a lot of questions, but I would like to keep our timing. And if I could ask you to ask the questions, to write down your questions, ask your questions at the end of our session when we have all presentations. Okay, thank you very much. So the next presenter is, thank you very much, Dan.
Thank you very much.
The next presenter is Rafał Kluziak, and he will talk about the Polish law.
Yeah, yeah. Hi, everyone. My name is Rafa Kluzak. I work here in Warsaw for CMS Cameron McKenna. Again, English law firm with branches around the world. I was asked to present you Polish system, how the investments look in Poland, and if you want to invest in Poland, what would you do, and how we could help. But first of all, I'm really impressed that so many of you turned up here Friday evening and chose to hopefully get a bit smarter than instead, for example, having a drink with your friends. But I guess this will happen later in the night. So let's go quickly through the Polish system. I work as a M&A lawyer, so we help both Polish and international clients to make investments, exit investments in Poland as well as abroad. We also work for Polish clients or international clients investing abroad. And we have few observations. What supports investments in Poland, and we can look at it from many perspectives. First, like more general and a global one, which is what Poland has to offer. First of all, it's quite a big country with good growth, a good economy, and very educated, smart people that are eager to work hard, like you do here, or some of you from Poland. So many, for example, many companies, they outsource parts of their business here, and Wrocław, Warsaw, or Krakow are hubs for such companies. They start from back office, but then they move their middle office, for example, partly due to Brexit. A few investment banks are moving their middle offices here in Warsaw. And why is that? Because we have pretty liberal employment laws, and this may be a surprise for you, but comparing to other countries, Polish employment laws are pretty liberal and employer friendly. It's a former communist economy, so Poland is trying to skip and run a bit quicker, so it supports R&D strongly, and you can get funding, tax preferences, preferential treatments if you invest Poland in those in a business like that. You can also be treated beneficially if you invest in certain special economic zones. There are some tax exemptions, so there are plenty of options if you want to invest in Poland. Of course, there are also few risks, especially lately. We have cases, since it's a former communist country and still developing economy, even if many want to think otherwise, it's still developing economy, especially if we compare it to English law system, which is probably 800 years old if you mentioned Crusades. our system is 30 years old, or modern business system. But even though that my older colleagues moved from States or Britain and implemented US and English law into Polish law, and we basically, when we talk to our English friends, we work on the English concepts. Still, the main problem is how we execute a law, and we have so many regulations, and we love to create rules, but then we don't follow them, and we don't follow them, then it means that we simply break them. And this is a problem of Polish system and Polish practice, that we need to explain clients that this is the law, but something very separate is the market practice, that we just forgetting about law and using the practice as rules. And one other issue, especially today, is that you probably couldn't see Poland on the list of the least corrupted countries. It's getting better, and big business is not affected as it was probably in the 90s, but the reputation is still not that good. Probably locally there are more problems than on a central level, because the risk is simply too high. The system is rather effective, but then locally is the connections, and the local connections are sometimes stronger than the rules of law. But there are also big cases of foreign investors that invested in Poland, and due to political situation may have some problems. There is a case of, again, arbitration based on foreign investments treaties, which was the case of FM Bank, owned by a private equity fund, which that private equity fund was ordered to sell the bank by the Polish Financial Regulatory Authority, the KNF. And then it was, we call it fire sale. So when everybody knows that you need to sell within a certain period of time, then everybody knows that they can pay a little money for an asset that is pretty good. And that's what happened. And that fund sued the Polish government and won the arbitration. Right now it's they're actually discussing how much the Polish government will pay for the mistakes of the officers working for KNF. But there are other political cases. I don't know if you are aware. We have few skiing resorts in Poland. One of them is Kasprowy Wierch. It's the oldest one. It dates back to the 30s when it was built. And a month ago, the Polish local government ordered to have it closed and closed because there is a political conflict between the owners, again a private equity fund, and the current Polish government. But there are protections against that, and we hope it will be resolved. So there are also political risks that we always inform, especially in such delicate matters or regulated investments. But if you want to invest in Poland, there are also many potential ways to how you can get funding for that. And if you want to we usually divide them by into equity funding, which is very strong in Poland, as well as debt funding, which was mentioned earlier. Banks in Poland are very developed. So we have one of the strongest banking systems in Poland. The money is cheap, and they're happy to loan you any amount if you have good idea, good business, and good security. They're happy to loan you any amount for good business. Also abroad. If you want to have equity funding, we have private equity funds, also very active on the Polish market, and Poland is a hub for private equity business for the CE. We have venture capital still growing, and it's supported by the Polish government, which so the government is not only bad but also good. It supports R&D, so they opened a few funds, one that invests in R&D businesses, one that invests in healthcare business, and one that invests in a new technology, and it's over 1 billion Polish zloty capital to be spent in next few years. So the Polish venture capital scene will be pretty hot. And there are also other types of funding, which probably I can skip. Which, if you want to get some funding, you'll discover that. But to sum up, if you're looking at Poland from a international perspective, it has great macro, some political risks, increasingly better, I would say, Polish systems and courts. Referring to your question, for example, we tend to, contrary what we did probably 10, 15 years ago, we tend to right now recommend our clients to have disputes either in Polish courts or before Polish arbitration, because it's getting better. We have more experts, we have better educated judges, so and it's cheaper and not as slow. Once or a few times we had cases before English arbitration or international arbitration, and it may be a bit quicker, but the cost of arbitration itself, it's a few €100,000. The cost of the court, so be aware of that. And the cost of all the lawyers involved, regardless of the value of the case, may be as high as probably €500,000 to €1 million. So they all fly business or first class. and it can take up to, I don't know, 2-3 years as well. So when we inform our clients about that, they prefer to stick to Polish courts, for example. And even though you may heard about the problems with the Polish courts lately, the kind of Polish judges are very stubborn, so probably they will survive again, and business judges or civil law judges will not be that affected. So you're safe still to invest in Poland, especially that it's been proved that even though there may be some political risks and disputes, you can always defend yourself and your business before international arbitration. Okay, thank you very much.
Thank you very much for nice recommendation for Poland. We have the next speaker, Matthias Stauffacher. And Matthias will talk about Switzerland. So Matthias, tell us how the situation looks like in Switzerland.
Can you hear me? Yeah. Yes, please. So first of all, I joined the other speakers before me in respect to all of you that you're still here. I'm here in two capacities. 10 years ago, I used to be the president of ELSA International. Today, I'm a partner at the law firm in Zurich, so there is a possibility after an ELSA career to actually become a lawyer. We often had these discussions that ELSA people, they're really like engaged and organized and they do a lot of things besides actually studying. So there is a chance for you. Actually, I will give, or I'll try to give you some information on Switzerland. I guess you're not familiar with Swiss law. Today, it will only be more of a commercial. Some of you will join the workshop tomorrow, while I try to go a bit more into the topic. So this is, again, it's more of a commercial than a really difficult legal thing here that I'm presenting. Some facts and figures. I got this from investment, like a special organization from our government that is looking for investments in Switzerland. So it is a commercial. I can tell you that three Swiss firms are among the 20 most valuable companies in the world. We're the top 3 nations with the highest number of Nobel laureates per capita. Number 1 currently is Norway. A motivated workforce. I really like this one. No general strikes for almost 100 years. So you see, we're motivated to work. I would base that more on a good welfare system, and I would say fair salaries still. World's highest purchasing power, which is often a topic for companies coming to Switzerland. And then a lot of patent applications. So these are mainly in the field of the pharmaceutical, healthcare sector, IT sector. We also had 10, if you're familiar with ICOs, initial coin offerings, it's a big topic now. I think out of the 20 biggest in the world, 10 happened in Switzerland. So again, a field where we're quite ahead or in the top of the market. Switzerland's most important trade partners, I think, is interesting because obviously we're surrounded by the European Union. I'll talk a bit more tomorrow about the European Union and Switzerland. Very important for us. Not so important for the European Union as we wish it would be. You see, 54% of the experts are traded with the EU. What I think is interesting is that Switzerland is the 3rd largest customer of the EU after the US and China. Considering we're 8 million inhabitants, it's quite big, I think. And Switzerland is an attractive location for investments. You can see 750 billion Swiss francs, which is approximately 657 billion euros. So there's a lot of investment, foreign investment coming to Switzerland. Again, some more numbers. I go through them a bit quick because you can find that on that website. There are a lot of international companies coming to Switzerland, having their headquarters in Switzerland. I'll come back to that why, or one of the reasons for that is a very preferential tax system. Of these companies that are coming to Switzerland, many of them coming from, again, from the European Union, from North America, from Japan and China. And here's some prominent examples. I think I don't have to read them. Most of these companies are known worldwide. So why are they coming to Switzerland? For me, it was actually surprising because I just gathered that information and I asked myself, like, what's interesting? I think Switzerland is attractive, first of all, because it's very competitive. You have very well-educated people there, but you also have a lot of your competitors actually being in Switzerland. For example, Google chose to come to Zurich, and Microsoft thought, okay, they must have had a reason, so they did it as well. They left in the meantime. Google got really strong, so Microsoft left. I'm not sure if there's a coincidence or... Then the finances of the federal government are very healthy. Also the cantons are very healthy, so we can allow ourselves to have very low taxes, which is attractive again for foreign investors. Then the market stability. We heard different examples before. We have a very long tradition in the UK that we don't have, but we're a bit more stable than Poland was. Also for our luck, I would say, historic luck. Finally, some news of this week. I just read it when I came here. Our finance minister just announced the numbers for 2007. He budgeted a loss of 280 million, and he ended up with a profit of 2.8 billion, where he kind of has a contingency of another 2 billion. So the actual profit would be 4.8 billion. Which does not really speak for his accountancy skills, but speaks for the economy itself. Now maybe let's go a bit more to the legal topics here because we're a legal crowd. This is one of the examples that I deal with in my professional work. Switzerland has some quite heavy restriction on buying real estate, which is only concerning non-commercial real estate. So as a foreign company, you can come to Switzerland, you can rent offices or buy offices or build industrial plants or whatever, but you cannot buy housing real estate. So this is also, it even includes being a shareholder of a real estate company. This is a kind of a protection clause, which is, I think, is a bit untypical for Switzerland because Switzerland has a very open legal system, but it's restrictive to real estate deals. EU citizens, they can buy real estate in Switzerland if they're living in Switzerland, which is the classical workaround. They move to Switzerland, they buy a house, they live there until they have the authorization, and then they leave again. Because it's only at the point where you require the authorization that you actually need to be there. Afterwards, it's your holiday home. Another workaround that I recently read about is serviced apartments. It's a lot in the Alpine ski resorts that you have serviced apartments. So if you bring breakfast in the morning, it's a hotel, and then again you can buy it. So just a fun fact, I would call it, of one of the restrictions of our legal market. Investment and taxes, and I think this is one of the reasons, at least, or many of the companies are coming to Switzerland. It's confirmed by the EU, so I think it's a fact that this is one of the reasons why a company is coming to Switzerland. One possibility is tax holidays, And these tax holidays, they can go up to 10 years. So if a big company, like for example Google, comes to Zurich, they negotiate their taxes they're going to pay, and they're probably not paying for the next 10 years any taxes. Obviously, they bring a lot of people working, or they create a lot of jobs, so it's not a zero tax income, but it's substantial for the company itself. Then we have a federal system. I'll talk about that tomorrow at length. And this federal system is pretty similar to the US system. So the states themselves, they have a lot of authority, and especially, again, they can give tax holidays. So you have the possibility to get a tax holiday on a national level, but also on the cantonal level. On the national level, such tax holidays are a bit more difficult to get than on a cantonal level. This is the same with the corruption. It's always easier on the local level than if it's a bit more global. It's my interpretation. I'm not sure if that is a fact, but I heard it from the Polish speaker before. Then the big issue, I'll bring up the next point, is holding companies. This is the big issue we currently have with the EU. There's even a more preferential tax regime for holding companies, which is under attack by the EU. Our administration came up with a new, very smart idea, and we took the referendum against it, and actually it was rejected. So we're back on field one. Our administration is starting again. The EU is complaining, and we're delaying. So this is what's happening. It's, maybe I can add here the quote of Albert Einstein. He once said, if there is ever a nuclear war, I go to Switzerland, because everything that happens internationally takes 10 more years till it arrives in Switzerland. So this is what we do, we delay. Now to the legal system, finally. After all these economic facts, the legal system. Switzerland is a federal state, I mentioned before. It's built up of 23 cantons and more than, actually 2,300 communes. The constitution is inspired by the US Constitution, and for the ones who are interested in the history of law, the US Constitution is inspired by the Genevan state constitution, and especially by Jean-Jacques Rousseau, one of the great philosophers from Switzerland who had a lot of influence on the building of the US Constitution. I mentioned before, the cantons, they have a broad autonomy, and I think this is one of the advantages of Switzerland, that you can actually have solutions very local. You don't always need the federal state involved. It's basically the other way around. It's normally the canton dealing with whatever, and then the federal state comes in if it's really like a bigger issue. But it's very local. So even me as a lawyer, I work very often with the authorities in Zurich and not with the federal authorities in Bern. Switzerland's political system has particularly strong elements of direct democracy. Again, a fun quote, I think half of all the votings in the world are happening in Switzerland. I checked this quote, but I couldn't find it, so don't take it for certain. But it's a lot of voting. And we heard before, we had a wonderful presentation on the different legal systems. Switzerland is a civil law country. I don't go into that because you just heard that. And I think it was very well presented, so I have nothing more to add there. Now, maybe the most interesting thing for me or for my work, and also for investors, are the issues between Switzerland and the EU. I mentioned before that we always are under the impression that the EU is constantly thinking about the relation to Switzerland. And then when we go to Brussels, we figure like, okay, they're not even during coffee break, they're speaking about Switzerland. So it's always this perception which is a bit wrong. But we are convinced that it's very important, because for us it's actually vital. So I mentioned before, the EU is the most important trade partner. There are two major packets of agreement between Switzerland and the EU, which is the bilateral 1 and the bilateral 2, which makes Switzerland almost an EU member with I always say with all the benefits, but just a few of the negative parts of the EU. And we're now stuck with bilateral 3. And we're really stuck because our National Conservative Party came up with a great idea to start a People's Initiative against mass immigration, and they were successful. And I think it's interesting to know it's mass immigration of Germans, French, and Italian people that we voted against, not immigration as it's often discussed in other countries. So it was basically a referendum against the EU, which we're not even a member of, just to give you an idea. We're constantly discussing the EU, even though we're not a member, but it's constantly an issue. And I think it will be much more of an issue in the future. The bilateral 3 should be a dynamic framework agreement, because what we have now is static agreements with the EU. We have agreements that have been negotiated, they are in place, but they are the EU law from 10 years ago or 20 years ago. And the EU law develops, but the static agreement doesn't develop. So how to deal with this? We don't know yet. And then finally, what makes the whole thing even more complicated, we have a very strong political opposition against the EU. Even though I would say we have a pretty good solution, still there's a lot of political pressure against the EU. And this, I think, again, will be an issue for the future. It will be an issue for investments. I can say that I'm working in the healthcare sector, and none of our hospitals would work without EU citizens coming or living in Switzerland, working there. Like half of our doctors have been educated, I guess, in Poland and in the rest of Eastern Europe. So, I mean, Switzerland is very depending on this, but the political opposition is very strong at the moment. And I think this will face in the next years, probably one time you read something in one of your newspapers about that the agreement didn't work out. And then we'll see what happens. And then we have the funny thing that happened recently. We had Brexit, which suddenly gives the same issues that we're dealing with since like 20 years. Now the British decided, let's do that as well, because it's working out great. Obviously, in our country, there were a lot of like, yes, they do it as well, so now we can just follow them. And they will have a great deal, and we just sign it as well, and that is going to be fine. I'm not so sure, we have an English colleague here, I'm not so sure if that's going to work out. We're also not so sure if the EU is really willing to give the same conditions to the UK as it will give to Switzerland. And then lastly, with all these negotiations, we made all these agreements with the old EU, and not with all the countries that joined the EU later, and are not so willing to give all these cherries to Switzerland, which I somehow understand, but 50% of the population doesn't. So I think you'll hear about that in the future as well. And again, I think it's a lot of my work is connected to these questions. I can say at the end, maybe you probably heard of the famous GDPR, the new data protection regulation, which applies in the European Union, which Switzerland is not a member of. I'm working daily on GDPR, because obviously, again, we have to deal with it. And I think this is important. If you want to understand Switzerland, it's very important to understand these relations, because that's what's like 50% of my work is dealing with these questions. So the rest I'll present tomorrow to the ones who are joining my workshop. Thank you for your attention.
Thank you, Matthias, for a wonderful speech. Let me welcome Mr. Singh for the presentation about Indian law.
Okay. Management of the university, management of today's conference, friends, my colleagues from the dais, good evening. Well, I'm a little bit late. I'm sorry for that, because I just finished a meeting with the Minister of External Affairs from Sri Lanka. That's a long story why an Indian Polish Chamber of Commerce is meeting Sri Lanka, but we are neighbors, so we have to. So that took me a little time, so that's why I'm late, but thank you for being here. And I can only say, with all due respects to my predecessors, the best is yet to come. Well, I made a presentation today about the Indian law in the broad perspective. I would like to take you to a distant journey, to tell you about a bit of the history, and then I'll come to the point what's going on right now. Well, India, of course, the largest democracy of the world, with a population of 1.3 billion, with 29 states, 7 union territories, and 1 capital. Now, if you see all the states, I especially didn't put the map, which I usually do, where you can just put the map of European Union, and actually, it's a kind of European Union, the whole subcontinent of India. It's a world third economy as per the PPP. Trade between India and Poland as of today in 2018 stands up little above $3 billion US. There are key strategic industries which have been decided by the both governments that we are working on in promoting the investments, the joint ventures and the cooperation. That's mining, pharma, food processing, medical equipment, chemical, IT, and the latest addition is furniture also. I'll tell you a little bit about that in the later part of my presentation. Now, I'll take you a journey of the legal system of India. I'll take you a little bit back, what was, with the Islamic law, English common law, modern Indian law. Now, just to make it clear, in the past, the law of India was based on the Hindu law. Traditional conception of law considered the oldest legal system. Having said that, the culture of India is almost more than 5,000 years old. Next was the Islamic invasion in India, which of course had the Islamic law, but that was not covered for the whole of India. I will touch that subject. Then we have the British colonization in India, which lasted for almost 200 years. And then we have the modern Indian law, which is effective, I would say, 1947, although the constitution was passed in 1950, and we'll touch that subject also. Now, the Hindu law, what the Hindu law is. Hindu law is not a law as understood in the modern times. A law in the present sense would mean an act framed by the legislature of a state. Hindu law has not been made by legislature, but it is a law made by the divine being which has been rebuilt in the Vedas. Now, the Vedas are the old manuscript. It's a religious book which has been referred to in the past when the law was applied during that time. It is dharma. Now, dharma is example the duties, rules of conduct, moral, religious, and political, enjoyed by the Almighty on the Hindu community. Thus, it covers all laws which are kept separate under the modern system of law. According to the Hindu law, those who violate the dharma shall be destroyed, and those who follow it shall be protected. Now, what are the sources of the Hindu law? As you can see on the screen, this is applicable both to the king and his subjects. According to Dharmashtrama, there are 4 goals of human life: Artha, Dharma, Kama, and Moksha. Moksha, or salvation, is the ultimate goal. As a matter of fact, Artha and Kama are concerned with this world, whereas Dharma and Moksha are concerned with the next world. A life in accordance to Dharma leads to happiness, well-being, pleasure in the present life also. The sources of Dharma, Shruti, have been considered as the authority in the Hindu Dharma. Now, what is Shruti? Shruti is something what you have heard about from the religious book. The smritis, such as Manusmriti, now the smritis are the things which you remember. It's a collection of the various things from the holy book, which at that time, the highest people in the society used to have it well versed and remembered, and they used to apply that for the Hindu law. These expresses that Shruti and Smriti and Achara are the sources of jurisdiction in law. The precedence of these sources is declared in the opening verses of each of the known surviving Dharma Sutras. You can see the copy of that book on the presentation. That's actually it looks like. Society. Well, under Hinduism, which is the largest religion in India, 80% of the population are Hindus. Then we have around 14% which are Muslim. And then we have around 1 and 2% each religions of Sikh, Jews, Parsis. Well, I'm sorry for that, but that's just to bring the attention of yours so you don't sleep at that late hour. So I'm creating that noise. So as you can see on the picture, there are various societies, caste societies in the Hindu religion. Now, if you see this picture, the Brahma, in the Hindu mythology, Brahma is the creator of the whole world. The caste system divides Hindus into 4 main categories. Brahmins, as you can see on the top, Kshatriyas, Vaishyas, and Shudras. Many believe that the groups originated from Brahma, the Hindu god of creation, as already said. Manusmriti, widely regarded the most important and authoritative book on Hindu law and dating back to at least 1,000 years before the Christ was born, acknowledges and justifies the caste system as the basis of order and regularity of society. The top hierarchy were the Brahmins, who were the mainly teachers, and the intellectuals are believed to have come from Brahma's head. Then came the Kshatriyas, or the warriors, and the rulers, supposedly from his arms. The third slot went to Vaishyas, or traders, who were created from his thigh. At the bottom of the heap were the Shudras, who came from Brahma's feet and did all the menial jobs. Now, till today, of course, in the Hindu society, that caste system does exist. Now, if you ask me, I'm an Indian, but I'm not Hindu. I'm Sikh. I don't have a turban because I don't have it from the beginning. But in the Sikh religion, we don't have the caste system. We treat everybody equal. But like I said, in India, the majority of the population, 80% are Hindus. That system you can still see, maybe not in the bigger cities, but definitely in the smaller towns and the villages, it's very visible. The Muslim domination. There is no proof of our administration of Muslim personal law until 1206 in Indian Peninsula, even though there were Muslim invasions during that period. The court of Shariat, assisted by the Mufti. Now, Mufti is the religious person in the Muslim religion, dealt with the cases involving personal law among Muslims. During Sher Shah's, one of the rulers at the Mughal time regime, the powers of Shariat court were restricted and Muslim laws were modified to suit the requirements of the times. Now, please remember one thing, under the Muslim domination also, Hindus were not tried by the Muslim law. Mughals permitted that for them, they will apply the Hindu law. It was treated, or I would say practiced, separately. During the regime of the Mughal kings, Babur and Humayun, the earlier laws were followed, and the ulemas, the religious scholars, had considerable influence on the legal decisions. During Akbar's regime, ulema's powers were significantly reduced and shattered the dominance of the orthodox Sunni school. Now, here's one thing which you should know. Akbar was the only Mughal ruler in India who had a Hindu wife. So that also shows the tolerance at the Mughal period, at the Mughal times, that they were allowed to get married outside their religion. Secular law in India varied widely from region to region and from ruler to ruler. Court systems for civil and criminal matters were essential features of many ruling dynasties of ancient India. Excellent secular system existed under the Mauryas and the Mughals. were later giving the way to the current common law system. The age of British domination. Now, the maps which I'm showing is actually from that time how the India looked. The common law system, a system of law based on recorded judicial precedents, came to India with the British East India Company. The company was granted charter by King George I in 1726 to establish mayor courts in Madras, Bombay, and Calcutta. As of today, they are known as Chennai, Mumbai, and Kolkata respectively. Judicial functions of the company expanded substantially after its victory in Battle of Palissy, and by 1772, company courts expanded out from the three major cities. In the process, the company slowly replaced the existing Mughal legal system in those parts. They are not interested in my presentations. Thank you. Following the first War of Independence in 1857, the control of company territories in India was passed to the British Crown. Being part of the empire saw the next big shift in Indian legal system. Supreme Courts were established, replacing the existing mayoral courts. These courts were converted to first high courts through letters of the patents authorized by the Indian High Courts Act passed by the British Parliament in 1862. Superintendents of lower courts and enrollment of law practitioners were deputed to the respective high courts. During the Raj, now we call it Raj, the British rule in India, the Privy Council acted as the highest court of appeal. Cases before the council were adjusted by the law, Lord of the Houses of the Lords. The state sued and was sued in the name of British sovereign in her capacity as Empress of India. Doors of the newly created Supreme Courts were barred to Indian practitioners, as right of audience was limited to the members of English, Irish, and Scottish professional bodies. Subsequent rules and statutes culminating in the Legal Practitioners Act of 1856, which opened up the profession regardless of nationality or religion. Codification in India. Coding of law also began in the earnest with the forming of the first law commission in India. Under the leadership of its chairman, Thomas Macaulay, the Indian Penal Code was drafted, enacted, and brought into force by 1862. The Code of Criminal Procedure was also drafted by the same commission. Host of other statutes and the codes like Evidence Act of 1872 and Contract Acts of 1872. Now come the change. Independence of India. 1947, 15th of August. A day earlier, Pakistan was created also. At the dawn of independence, the Parliament of Independent India was the forge where a document that will guide the young nation was being crafted. It will fall on the keen legal mind of Mr. B.R. Ambedkar to formulate a constitution for the newly independent nation. The Indian bar had a role in the independence movement that can hardly be overstated. The tallest leaders of the movement across the political spectrum were lawyers, is ample proof of that. The new nation saw its first leader in Jawaharlal Nehru, the first Prime Minister of India, and paternal figure in Mahatma Gandhi, both exemplary lawyers. Perhaps it is consequent understanding of law and a relation to the society that promoted the founding fathers to devote the energy required to form a constitution, to devote the energy to form the constitution, sorry for that, unprecedented magnitude in both scope and length. Current legal system of India. The Constitution of India is a guiding light in all matters executive, legislative, and judicial in the country. It is extensive and aims to be sensitive. The Constitution turned the direction of system originally introduced for the preparation of the colonial and imperial interests in India, firmly in the direction of social welfare. The Constitution shows, through the judicial interpretation, seeks to empower the weakest members of the society. India has an organic law. As a consequence of common law system, through judicial pronouncements and legislative action, this has been fine-tuned for Indian conditions. The Indian legal system moved towards a social justice paradigm through the undertook independently can be seen to mirror the changes in the other territories with the common law system. Now, like I said earlier in the first slide, it's a federal republic. We are the federation of 29 states, 7 union territories, and 1 national capital territory, which is New Delhi. Prime Minister heads the government. President, head of the state. Now, President doesn't have that much of power. I can say it's only a symbolic position in the Indian Constitution. Electoral is where the power is, because the people elect the parliament, the lower and the upper house, and the parliament later elects the ambassador. Now, the supreme power for the law lies with the Supreme Court in India, where we have at present 31 judges. Now, these judges are actually elected by a collegium of judges. If there is any kind of a tussle between the nomination, the president has the last word in appointing the judge for the Supreme Court. Now, that's the present time. You can see the picture of our Prime Minister Narendra Modi with Professor Galinsky. That was 1.5 years back, when as a Chamber of Commerce, we headed the largest delegation to India, one of them, because we have been quite active in taking delegations from Poland to India. Now, India right now is a state or a country where the investments are flowing in. After the election, where the present government came to power, Mr. Modi has made all the possibilities to put the map, or India on the map of the world. As you can see, in the last in January, when we had the Davos Forum, India was a key partner of that. India has received the inflows of FDI worth 60 billion in 2016, 2017 alone, which was all-time high. Last year, in August, the Department of Industrial Policy and Promotion has issued the updated and revised Foreign Direct Investment Policy 2017 and 2018. This policy actually incorporated various notifications issued by the Government of India over the past years. Now, you might have heard or not, but the main slogan of the Prime Minister Modi is cutting the red tape and putting the red carpet. So this is to invite the investments to India. Words are not the only, I would say, words, because they are doing a lot of ground job also in making things easier. You might have heard last year when there was a demonetization of the Indian rupee. Of course, that was done also specially to make sure the people are paying taxes. Please note that in India, unfortunately, till I would say 2017, only 5 to 6% of the people were paying taxes. Others were paying taxes, but not on the actual income. So you can imagine why that movement was necessary. Of course, it's very painful. I remember myself when I traveled to India during that time, to change the money into the Indian rupee was like a nightmare. But people sustained. They understood why they are doing it, because the people themselves, they wanted a change. Of course, there's a debate on it, what is the actual outcome, because we still don't have the exact figures from the reports from the Reserve Bank of India. How much of the money has come in to the coffers of the government, but I hope by the first quarter, end of the first quarter 2018, they have promised that we'll be having that report, which will be handed out not only to the Indian nationals, but to the whole world to show why this was necessary. Now, few of the things have been made. I will just give a little bit of information on that to make the things easier for the foreign investment. Abolition of the Foreign Investment Promotion Board. The most important amendment to the FTA regime has been the institutional change brought by the notification last year issued by the Department of Economic Affairs, confirming the abolition of, I would say, the Federal Investment institution which was there, which was controlling everything. To make it easier, they changed to the Foreign Investment Facilitation Portal. Now here, of course, the investors can go in. They can make the arrangements in a sense in what they're interested in. And the body which has been actually, I would say the next point which you have, the introduction of the competent authorities, they would decide how the things will go further. Now the competitive authorities are empowered to grant government approval for the FDI in respect of applications for FDI in single brand, multi-brand, and food product retail trading, and the Department of Economic Affairs of India for the FDI in the financial services sector. Now you should understand one thing, that a couple of years back still, these sectors were off for the foreign investors. Now result of that, we can see today the companies like IKEA, they're investing in India, and they're also taking the Polish furniture producers from Poland to invest with them in India because they like the quality what the Polish producers are giving them. So this shows how one change in one country can affect another country also, which will gain from it. Introduction of standard operating procedures to process FDI proposals. The Department of Economic Affairs also issued SOP, which is Standard Operating Procedure, which sets out the detailed procedures and timeline for applications, as well as a list of competent authorities for processing government approvals for FDI in India. Under this, investors are required to make an application on the website of the portal, supported by the specified documents, which inter alia include relevant charter documents, board resolutions, etc. The applications shall then be forwarded to the concerned competent authority and the Reserve Bank of India for comments from a foreign exchange law perspective within 2 days, 48 hours. Proposals requiring security clearance in sectors such as defense and telecommunication shall also be forwarded to the Ministry of Home Affairs. The competent authority shall process complete proposal and convey the approval, rejection of such proposal to the applicant in format prescribed under those SOP. Revision to the existing provisions of the FDI policy. Now, when we are saying that of 2016, this shows also how the Indian government is standing to the call of the investors. They are seeking, if their change is required every year, they are going to do it. The FDI policy of 2017 also incorporates all press notes issued by the DIPP during the course of year. I will give you a bit of the information on that. Manufacturing. To further liberalize the manufacturing sector, now this is very important for India right now. You are seeing that Make in India, because that's a drive for the present government, is actually after and making sure that investments come to India not only in the form of monetary, but actually the businesses start up their manufacturing hubs in India. The sectors which allow 100% FDI under the automatic route. Now the automatic route in the Indian investment law means where actually you don't require the direct approval from the government, which are the easy investments. Under the government approval route, allowed 100% FDI under the government approval route is allowed for retail trading. I just mentioned about the IKEA, including through e-commerce in respect of food products manufactured or produced in India. Civil aviation, which is a very huge industry in India. The threshold for the FDI in existing projects under the automatic route was increased from 74% to 100%. Now we all know Air India, the national carrier of India, is an ailing airline. Now things are being set, and it will be one of the biggest privatization moves in the Indian history in the civil aviation this year. Single brand retailing, sourcing norms applicable for FDI were relaxed and will not be applicable up to 3 years from commencement of the business. Example, opening of the first store for entities undertaking the single brand retail trading of products having state-of-art and cutting-edge technology where local sourcing is not possible. Now here, IKEA falls under this prospectus partly. Other financial services, the previously applicable capitalization norms for non-banking financial sectors and services, companies were struck off, and all financial sector activities by entities already regulated by financial sector, regulators fall under 100% automatic route for investment with applicability for sectoral laws. Now, these are the huge changes, and we are promoting that not only in Poland as being the Indo-Polish Chamber of Commerce, but each organization, each embassy of India all over the world is making sure that the message is out and is being heard. I would like to share some thoughts in the end. The changes in the FDI policy of 2017 display the effort of the Indian government to remove of multiple layers of bureaucracy. That's what I meant by the red tape. And to process proposals for the FDI under government approval route in more streamlined, positive, and expeditious manner. The government has eased 87 FDI rules across 21 sectors in the last 3 years, opening up traditionally conservative sectors like rail infrastructure, quite important as perspective of Poland, and defense, too. Even Indian agriculture sector, which has been barred from the foreign investment, got the FDI worth $78 million in 2016 and 2017. It is expected that the government will continue to bring about liberalization of the FDI regime in India in months to come. All in well, we intend to maintain our trajectory towards remaining the world's most attractive destination for foreign investment. So friends, from the artifice of the colonial masters, the Indian legal system has evolved as an essential ingredient of the world's largest democracy and a crucial front in the battle to secure, and I will underline that, constitutional rights for every citizen, irrespective of religion and caste. Thank you very much.
Thank you, Mr. Singh. I guess some of you have waited for this time, and now it's time for discussion and questions. So we have a few. Yes?
Thank you.
If you just could introduce yourself.
Yes,
Okay?
I'm Peter. I'm from Hungary. And I have a question to Mr. Singh. The question is, doesn't failure of enforcing foreign arbitral award sets back foreign direct investment to India? I mean, recently, in the last couple of years, two great cases like Divas and White Industries that had great publicity and great compensations awarded to these companies because Indian courts were reluctant to protect their investment. There were commercial investment cases, and later it brought to investment arbitration that had great harm to investment security, and that had bad reputation to the citizens also. So I'm asking if there was any changes or if there an intention to change the Indian courts to afford and to protect foreign investment arbitration awards. Thank you.
Thank you for the question. Now, that's what happens when you're the last presenter. You get the first question. Well, I will first underline, of course, as a perspective of Indo-Polish Chamber of Commerce, I will say from that perspective, because I'm not a lawyer, but definitely the 2 points what you have raised about that, they were quite significant in the news, and that definitely gave certain thoughts to the foreign investments or the investors to think twice if they would like to invest in India. Now, what you have seen, what I've been talking about, the changes which has been done to attract the foreign investments into India, that doesn't go only in the streamlining the procedures for the investment, but that also goes with changing the certain laws. Now, to give you the example of that, if those things have not been in place, companies like Apple, companies like IKEA would never have thought of investing in India, especially the previous one, the Apple, because they have a very, I would say, the sensitive matters in those subjects. And definitely it is happening. I will be very frank, the things doesn't change overnight, all right? It's a very complex democracy of the world. Certain things take time to change, but definitely they are on the good route. And this shows also the information which I shared with you all, that we have received a 60 billion of the foreign investments in 2016 and 17 alone, that things are changing.
We have some questions, some more questions. I saw some hands, yes. Right
The
there.
ladies, yeah.
Ah, okay, yes, lady.
Hello, my name is Sarah. I study in the UK. I have two questions for Mr. Kaka and one question for Mr. Stauffacher. So firstly, I got the impression that you think that litigation in the UK is the best means of dispute resolution in financial law disputes. And I would just like to know if you still think that, following from the Demon litigation, because surely it must be best in the field of financial law to secure harmonized interpretation of contracts worldwide, and Lehman litigation shows that that's not the case if you choose litigation, and in that case, would arbitration be a better means of dispute resolution? Secondly, I would like to know, because you mentioned that pro-debtor legal systems may be better for the economy, and for that I would like to know if you still think that, given the fact that there is a risk of misuse of the Chapter 11 procedure due to the stay on enforcement and the opportunity for businesses to cherry pick which contracts they wish to move forward with and which contracts they wish to terminate. And for Mr. Stauffacher, I would like to know if you could expand on the challenges that the GDPR presents for Switzerland, especially regarding the financial sector. Thank you.
Okay, shall I start off then? The first question then is about litigation and arbitration, focusing in particular on the Lehman Brothers litigation and harmonization of contracts. So, which is better, litigation or arbitration? I think it depends on some of the factors that I mentioned earlier. And in particular, one advantage of litigation over arbitration is that everything is in the public domain. It is open, it is fair, and perhaps most importantly, in a common law system, judicial precedent is created for other cases. And one of the things that we miss out on in English law with the rise of arbitration is the lack of possibility for creating judicial precedent, because so many of the more complex cases are heard in arbitration. So clearly the two have their pros and cons, and I think it's really, at the end of the day, up to the parties to decide. And the great thing is that the parties do have the option to decide what works best for them, which is consistent with the English law principle of freedom of contract, that two grown-up parties with relative equality of bargaining power are entitled to make the choice. Clearly there is a protection for consumer contracts where there is an inequality of bargaining power. So yes, I think at the end of the day it should come down to freedom of choice. The second point about misuse of Chapter 11, and there, under English law, there are several different systems of insolvency proceedings, and I have had some experience of the administration proceedings, which are a little bit closer to Chapter 11, in that the obligation of the administrator is to preserve the business as a going concern. And I worked on some cases in the public sector when it came to the insolvency of Metronet, the London Underground service company that basically ran half of the London Underground. And there the overriding factor was to keep the tube running. And there was a special administration procedure there where decisions were made about which contracts should be terminated, which should be kept. And there was the sort of overriding factor about maintaining the public service. So yes, I think the conclusion is, again, depends on the circumstances, and there will be some cases where in more ordinary businesses it is perfectly right for the creditors to be able to seize the assets and protect their interests. The next question.
Thank you. You raised a question concerning GDPR, and I can say one thing. First of all, GDPR is so important because of the heavy fines. That's why everyone's concerned. And the second point is that it applies to EU citizens. So if you service EU citizens, and I mentioned before that Switzerland has a very global economy and a lot of businesses that have focus on the EU, so they have to apply and respect the law. An interesting question is which law? Because is it Germany? The applications of the GDPR, there's a lot of national extensions that you can and exceptions. So we're not really sure which one to choose for Switzerland. And what concerns the financial sector, that's probably the one exception to the GDPR regulation, because in the financial sector you have legal grounds for collecting data. Because in the financial sector there are very strong regulation on money laundering, and you have to know your client, so you're obliged by law to actually collect data. So for once the financial sector is not exempted, but is really not concerned that much. It's all the other businesses that are concerned. Thank you.
Okay, so the next question.
Hi, my name is Daria, and I have two questions and one comment. First, I will start with the comment about the question that a colleague asked her, my friend, and I think that she meant the convention, like the International Convention on the Settlement of Investment Disputes. And the thing is that in the convention, it states that you can annul, an award. And there are 5 grounds on which you can annul it. And what is that important in this convention is that, yes, it is an arbitration court, but it is an arbitration court between one party is a country and the other party is just a private party, right? So I think, and in the 90s, it was really, really common just to enter into this convention. But now I think there's another trend, the trend trying not to be under this convention, because a country per se, as a sovereign country, being given an award with no possibility of annulment of the award or no possibility of the appeal from the award, I think that the balance is a bit unclear here. So I think that's why I think you were asking about this convention. So that was the comment. And then I've got 2 questions. First would be to maybe both Dan Cocker and Matthias Stauffacher about the, maybe I would go awry a bit, but I think it's also important in this topic because we are talking about investments here in specific jurisdictions. And you mentioned that, for example, in English law, there is the whole idea of trust that we don't have in Poland, for example, or I'm not sure about Switzerland, but I know that Liechtenstein, they have this notion of Stiftung, which is more or less the trust notion. And the thing here is that, do you think that those countries are so popular for investment because it is possible to cover the ultimate beneficial owner, which is behind those kind of forms, the legal forms? So if you can just say something about that. And then that's just for Matthias Stauffacher, about the Switzerland and the whistleblowing policy, because I know that there's been in 2010, more or less, I remember there were cases where it was Rudolf Elmer, I think, he was imprisoned for leaking certain documents for WikiLeaks. And we all know that Swiss law is the law of secrecy. So has that changed? Because I think that also that was one of the points why the investment was so popular in Switzerland. Thank you.
Okay, to respond firstly on the comment and the talk about ICSID arbitrations and bilateral investment treaties. I think that may not have been the point, but I will mention the great benefits of bilateral investment treaties, in that I have a client who developed a hotel project in an African country, and there was a regime change, and the new government came in, sending troops into the hotel with Kalashnikov rifles. I saw the video footage of this, took over the hotel, didn't pay any rent. So my client phoned me up and said, what can I do? And I said, well, there probably isn't very much, but I will speak to my litigation colleagues. And I duly did, and we found out that there was a bilateral investment treaty between my client's country and this particular African country. So we waived this bilateral investment treaty in the face of this particular African country, and they wrote a check to compensate the client for the loss of the hotel. So that's a great advantage of bilateral investment treaties. Coming on to your question about the trust, is it a means of covering up ultimate beneficial owners for potentially shady dealings? And in this current world, whenever a financial institution is going to be involved in a deal, it will do some very rigorous KYC, know your customer checks. And certainly any financial institution that I have had any experience of dealing with would insist on getting to know the ultimate beneficial owner of any investor, which involves looking behind any trust and so on. And if the tests are not passed, there is no question of that financial institution lending or investing. That there may well be jurisdictions, offshore jurisdictions, in which it is easy to conceal ultimate beneficial owners, but the question is who is going to do business with these entities? Okay, and the next question was for
me. Thank you for the question. You probably noted that I left out the bank sector in my, or the financial sector in my presentation, which is, I would say, pretty unusual, because was for a long time the stronghold of Switzerland. I have two anecdotes for this. One is of a banker, famous bank, Julius Baer, is a private bank. He wrote a book about the banking industry, and he said that in the 60s it was common that people came into the bank with a Hennessy bottle, was one example, and said, all you need to know is I'm Mr. Hennessy. And that's how they dealt. So that was not exactly investment. That was more saving money. But times have changed, and as my colleague just mentioned today, even though we also have trusts, and as you rightly mentioned, they're called Stiftungen in German, but it's basically the same principle. But during these times now, the bank really, they changed their businesses. These practices do not, I wouldn't say they do not exist anymore, but they are close to not existing anymore. They do not exist anymore towards the US, and they tend to not exist anymore towards the European Union. I cannot speak out for third world countries. There's still some banks who try to survive with this old system because they just made a lot of money with it. I have another example of a professor of mine. He once told me that, again, as a lawyer in the 70s and 80s in Switzerland, it happened that someone came up, gave you 10 million and said, my name is on no papers, you can keep 1 million and you just take care of the rest. So that was actually a business, and a partner in my firm, he's an expert in financial markets, and he said that these lawyers now have to actually practice law, so they have to learn a new job, because what they did before had nothing to do with law. So I can say I didn't expressly not speak about the financial market because I think it's really changing currently, and it's not this bank secrecy that we had before. I think it's losing importance. Now it's more about the political stability, about the Swiss franc, which is a very strong currency. So these things are getting more important than the bank secrecy. But you mentioned the case of Elmer. Funny that you know about it, about whistleblowing. You met him. About whistleblowing, that doesn't exist in Switzerland, whistleblowing. The bank secrecy exists. And Elmer got, I think he had to go to jail. So there is no whistleblowing protection there.
I was wondering because he was mentioning that it was in the process of like being changed. So I was wondering if...
No, that didn't happen.
He's still waiting inside?
No, he's out, but whistleblowing is really something that is not very popular in Switzerland. The mentality is still on secrecy, but it's changing. The US taught us how to.
Hi, my name is Rachel. I'm over here. I'm also based in the UK, and I have a question for Mr. Cocker. So as you touched upon in your presentation, many companies choose English law to govern their contracts, and many also refer disputes to the London Court of International Arbitration. Research that I read recently said that 47% of companies surveyed said that this was their favored destination for arbitration. So my question is, with Brexit and the rise of Hong Kong and Singapore in this sector, do you think London will continue to be the go-to for arbitration, and will English law continue to be so popular for commercial contracts?
Okay, great question. I have to declare an interest in that one of my partners is the president of the London Court of International Arbitration, so I guess we as a firm are very supportive of the LCIA as a means of disputes resolution. But we are also very supportive of Hong Kong and Singapore, and an increasing number of our lawyers have been moving to Hong Kong and Singapore because they are regional centers of dispute resolution. So do I think that Hong Kong and Singapore are going to replace London? I would say not particularly. But they are going to be regional centers for the Asia-Pacific region, deciding disputes under whichever law it might be, Hong Kong, Singapore law for the procedural rules, but also under other common law systems in the area. To answer the second part of your question, do I think that English law will fall in popularity as a choice of law because of Brexit? And the answer is absolutely no. There is no reason why it should, because even once the UK leaves the EU, it will still be the case that many countries' national rules on recognition of choice of law will respect parties' contractual choice of law, regardless of any international conventions that the UK may be a party to. So I think for some of the reasons that I mentioned, English law continues to be extremely popular in Europe and the Asia-Pacific region, whereas in the Americas, when it comes to choice of law, clearly New York law is extremely popular in that region. So I would expect it to continue to be a regional thing, and I don't see any reason why English law will become less popular after Brexit.
Hello, I'm Thomas. I'm from Poland, but I'm studying in Germany. I have two questions. The first one to Mr. Cocker, it's about the Brexit. Do you think will it increase or decrease the attractiveness of United Kingdom as a place for investment? I mean, is it more opportunity or a threat to the English economy? And the second question is to Mr. Krujak. Apart from the political situation and this liberal employment law, how do you think, from the point of view of a foreign investor, what is the biggest opportunity and the biggest threat of investing, of making an investment in Poland? Thank you.
Okay, in answer to the question of Brexit, I have to say that I get slightly embarrassed and ashamed when I have to answer questions on Brexit. I did not vote for Brexit. I would never have voted for Brexit. I think Brexit is the greatest disaster which democracy has ever inflicted on the United Kingdom. And it's very rare for a lawyer to have to give this answer to a question, but the answer is, I don't know, and no one knows. It is impossible to know. In terms of the Brexit fallout, we are at such an early stage that we have no idea whether it's going to be an opportunity or a threat. There are so many variables. As a country, we have thought very little about Brexit. When David Cameron promised the Brexit vote, it was a short-term political fix. There was a yes or no answer, which was very unsophisticated because no one knew what they were voting for with Brexit. So will it be an opportunity or a threat? Let me try to speculate. I think it can be a huge threat because other EU members have expressed enthusiasm for punishing the Brits for being so stupid and voting for Brexit. And could it be an opportunity? Potentially, yes, because some politicians have said, well, if we are punished, we will go for a low-tax regime, which will encourage everyone to locate their businesses in the UK at the expense of other member states. So that's my view.
Thank you for the question. I'd like to answer your question on two levels. First, legal, and then more general, economical. The biggest opportunity in Poland is its market. We have growing market, still quite young, very well educated people. So we predict, and this is based on the discussions with bankers, with investors, that foreign investments will still flow into the country. The market is not saturated, is not as competitive as, for example, Switzerland or UK. So we can be safe here. The threats are the threat is mainly unpredictability, because new ideas pop out. There was an idea of introducing a retail tax, more taxes on individual entrepreneurs, more business taxes, and everything to actually pay for benefits to voters, to win votes. So this is the biggest threat, because what the investors like, they like predictability. They're fine even with the problems in economy as long as they're predictable, because they just change the number of the percentage of risk in their spreadsheet, and they can decrease the value of the company they're buying, and that's as simple as that. But if everything changes each two years, then they just stop investing because they can't put the Excel sheet together. And that was the problem, for example, in the first, I would say, a year and a half of the new government. Right now, it becomes, I would say, unpredictable becomes predictable. So they increase the risk, and they expect higher returns, and it impacted the valuations of the companies and businesses in Poland. So this is the biggest threat, and legally, that threat is how the government impacts the Polish courts, and it depends if they really want to start messing with the civil law courts, because the criminal cases are not particularly interesting to the investors, unfortunately. So as long as they don't touch business, they will be fine. And I don't think they will. But the opportunity is that more and more Polish business is moving abroad. We see increasing numbers of successful Polish businesses investing in France, Germany, UK, Denmark, and multiple other countries. And they grow bigger. Poland becomes small enough, because it was big enough market to feed the growth of even considerably large Polish companies. But right now it's becoming likely small enough, and they invest, they move their businesses abroad. So this is the opportunity for them to generate revenues abroad. And I think it's good, because it's a painful process in the very beginning, because you need to learn new legal regimes, new business rules, new cultures, but then you can grow your business way quicker. Thank you.
Thank you very much. I know that everyone, we have still, okay, still one question, yes.
I'm sorry for that question. It might seem a little bit strange, but I'm just curious, and that is why I want to ask that. Well, yeah, by the way, my name is Dana, and I'm studying in Lithuania and France. And what I wanted to ask, I have a question to Dan Cooker. The question is about the differences between jurisdictions, English jurisdiction in particular, and some jurisdictions of continental law. So, as you mentioned, that a lot of investments are a lot of agreements or I don't know, like contracts are made under English law, even though because it's like really cool and everything. But the thing is, that a lot of law systems, they have differences, right? So if it's, for example, it's actually maybe more question of contract law. So if we take the situation of changes of circumstances that English law doesn't know, let's say, like as far as I know, and that exists in German law and in French law, let's say like doctrine of l'imprévision. So if a person, can it be an obstacle that English law doesn't have, let's say, this element, or the other elements that are different in English law, can be an obstacle for investments? Thank you.
Okay, thank you very much. What a great question, and I particularly liked your comment that English law is really cool and everything. I had never realised that, but it will make me do my job with ever greater enthusiasm, knowing that it's cool. So thank you especially for that. Coming on to your question, the fundamental point here is that with English law and English contracts, they pretty much do what it says on the tin, as you might say. If you have, let's say, a German law contract, I will use German law as an example because I think there's no German lawyer in the room to contradict me. And I know a little bit about German law. You have to read two or three documents. So in your left hand, you have to have the contract. But in your right hand, you have to have the civil code. And in another hand, you have to have the commentaries on the civil code to know what the contract means. And you have to realize that you might have to imply, for example, a change in circumstances clause. Whereas with an English law contract, the deal is essentially exactly what the parties agree and write down in the contract. English law has huge respect for the doctrine of freedom of contract, that equal parties are free to agree whatever they like within reason, and won't start imposing legal doctrines to upset the deal that has been agreed with the parties. And that is extremely attractive for commercial parties who want predictability in a deal. And there are some English law mechanisms, such as the concept of the option, which are not recognized under other legal systems, which will make English law the law of choice. Another example is good faith. There is no expectation of good faith under English law, except in limited circumstances, such as the contractual relationship between employer and employee, or insurer and insured, where there is the case of uber rima fide's utmost good faith. So do I think this is good for doing business? Answer, yes, because the parties can do the deal that they want and that they document, especially if they choose some suitable lawyers to help them document it and make sure that the deal is all written down.
All right. Thank you very much. I think that everyone is tired already. We are just on time, so it's 8 p.m. I would like to thank you all panelists and all participants that you're still listening to us. And I would like to invite you for the next day. Tomorrow is the next day with the new sessions. Thank you very much and good night.
I would like to share with you some logistical issues from the organizing committee. So, as you may know, we've prepared not only the academic program, but also the social one. So we meet each other at 10 p.m. in Opera Club. That's the basement of the National Theatre. The dress code is smart casual, so we will be more than happy if you join us. The second important information, our workshops tomorrow. Please be a little bit earlier, so 15-20 minutes. Check once again the address of the law firm when you attend your workshops. That's a very important one. And also we remind that it's still possible to attend the Gala Ball if you are not registered yet. The Gala Ball is on Saturday also at 8 p.m. in CBR building. That's the heart of the Old Town in Warsaw, Krakowskie Przedmieście, 66th Street. If you are interested in attending the Gala Ball, please contact the OC members. Thank you very much and see you tomorrow during the workshops. Thank you for your participation. There are chosen. Actually, I did it already. You've been registered. But yes, I'm not sure to which ones, and I would like to check. Okay, but email with information, confirmation. Yes, I uploaded this Google form, but I just didn't receive like the response. Can you wait? Co? Tak, bo zdjęcie tylko, ale zaraz za minutę, tylko zrobimy zdjęcie z prelegentami i będę. Can we take a photo together? Yeah.
If you want to take it,
Let's
do it now.
Yeah, in front of the big podium. Where is Mateusz?
Excuse me? Mr. Singh has to go.
Problem z Unią i tak dalej.